jury in the sex crimes trial of movie producer Harvey Weinstein has left for another day with no verdict, yet there is much to discuss. That jury worked for about 5 hours Tuesday, about 6.5 hours yesterday, and for about 7 hours today. This image of defense attorneys Damon Chironis and Donna Rotuno sums up the wait. Law&Crime's Jesse Weber has been waiting for us inside that courtroom. He's live outside right now. And Jesse, late this afternoon, a request for more readbacks of testimony.
Aaron, strange day, weird day, very quiet for the majority of the day until about 4:30 when it was a few minutes before the jury was to be dismissed. They had two notes for the judge. Note number 7 was requesting cross-examination and everything afterward of the testimony of Annabella Shora. You remember she claims that Harvey Weinstein raped her in the 90s, and of course she supports the highest charge of predatory sexual assault. Note number 8, they also wanted a list of anyone that she spoke to about the event, and they also said that they were done for the day. Now, I had to leave, but I did hear Judge Burke say that he can't give them that list because it wasn't in evidence, but it appears that they are going to get that readback. Today was a weird day where it was mostly quiet. We didn't hear much. It was a courtroom packed with reporters and spectators, all waiting for something to happen. Mr. Weinstein wasn't there for the majority of the day. He was in a separate room, which is understandable. Maybe the idea here is if you were waiting to hear the fate of your life, would you want 80 reporters watching your every move? Probably not. We did see several people enter the courtroom, some notable people, including family members of the defense attorneys. I had a chance to speak with Donna Rotuno's uncle. New York District Attorney Cy Vance entered the courtroom. He exchanged several words with prosecutor Joan Aluzzi. The day started off with the jury reviewing the materials that they requested yesterday, and like today, it's all about Annabella Shora. They wanted copies of communications between Weinstein and defense witness Paul Felcher, an alleged friend of Weinstein and Shora, emails to or about Annabella Shora, communications regarding Black Cube or Guidepost, the firms that Weinstein allegedly hired to investigate Shora. Now, we did see some colorful commentary from attorney Gloria Allred, who represents Annabella Shora, and she had this to say about this very subject matter. Take a look.
Annabella was in his world, meaning that she was more likely to be believed if she did speak out. As I sat there this morning, I wonder if, since they tried to silence me yesterday as the attorney for some of the witnesses for the prosecution, 3 witnesses who testified, if I am now going to be investigated by Black Cube.
So with the third day done, Aaron, the question is, are we even closer to a verdict? It's hard to say given these questions, but only the jury knows where they want to go tomorrow with the continuation of their deliberations.
Law&Crime's Jesse Weber there at the courthouse for us tonight. The jury, of course, is considering 5 charges. The first 2 relate to accuser Mimi Haley, while the last 3 relate to Jessica Mann. Predatory sexual assault is the top charge, which ties in accusations from actress Annabella Shora, whose claims cannot be prosecuted because they happened too long ago. The Weinstein jury is made up of 7 men and 5 women. Half of the jury consists of white men. 1 black man, 2 white women, and 1 woman of Latino heritage are also on the panel. The 3 alternates remain on standby. Several of Weinstein's accusers are not happy about the way the case is playing out. Though none have been present at the courthouse since opening statements and few have granted interviews since then, some have taken to Twitter. Rosanna Arquette tweeted, "For those who think the Me Too movement is in danger, you have not seen anything yet. No matter what happens in the Weinstein trial, the voices of countless victims of abuse worldwide will not be silenced, and predator rapists and the people that enable them will be exposed." Mira Sorvino tweeted, "We the silence breakers, we the women to whom Harvey Weinstein did irreparable harm to our bodies, our psyches, our careers, and sense of well-being, we know the truth. Harvey did everything he has been accused of many times over. Don't believe his minions. Guilty, #convict Weinstein." 3 attorneys are here for analysis on the debrief. Brian Buckmeyer and Adam Conta practice law here in New York. Dina Dahl is an attorney and trial mediator in Los Angeles. Dina, I want to start with the legal issue of consent here. The 2 accusers here upon which this case is built, Mimi Haley, Jessica Mann, both admitted to some consensual sex acts with Weinstein. Legally, though, you can have 10 million consensual sex acts with someone and still have 1 legal act of rape. Listen to how the defense described its strategy of tying everything together.
Well, sure, that's a completely different issue here, but I think what you have to look at is what your attitude is after the fact, what your actions are after the fact, how you behave, how you treat someone, what you do, what you tell your friends. I think all those things matter.
That was before this week's order from the judge that Donna Rotuno not talk to the press. But Dina, here's my question. Is the defense blurring the law, and is the jury potentially stuck because of it?
You know, yes, this consent is so interesting. The Mike Tyson case, maybe 25 years ago, the idea if somebody went up to the hotel room, she consented to everything after. Here is the reverse. Even if there was an act, if depending on how the woman acted afterwards, maybe the consent was retroactive. That is in essence what the defense is trying to say. But the fact that the jurors are asking for readout of all of the information, who these women talked to afterwards, I think shows that the emails and talking alone is not enough. And they are looking to how credible are these witnesses testifying to the act.
Brian Buckmeyer, if you're a defense attorney covering a case like this, litigating a case like this, what's going through your mind at this point? Are you looking at these jury questions and saying, boy, they believe the state's case or they don't believe the state's case?
When you're defending any case, whether it's Harvey Weinstein or someone else, you're fearful of assuming. But the one thing I would assume, and I think is beneficial, is when they come back and ask for the cross-examination of one of the biggest witnesses, because Annabella Shore is the one that gets them on the 2 top counts of predatory sexual assault, and they're only asking for cross-examination. I would have a glimmer of hope as a defense attorney, and I think the prosecution might be a little bit worried just for that.
Interesting insight there, Brian. Adam Conta, Judge James Burke has been criticized for his decisions in this case, sometimes his tone of voice, apparently even imitated lead defense attorney Donna Rotuno for asking to close a window in the courtroom because the cold air was getting in. You practice in front of this guy regularly. Is this typical? How does he behave in court?
Oh, this is just Burke Burking around. Yeah, he's a tough judge, and if you show weakness, he can exploit that weakness. But I don't think he's an unfair judge. He's just difficult, and you have to understand that as defense attorneys. But that's part of our job with every judge. Every judge acts differently, and you as a defense attorney needs to know the differences of those judges and act appropriately so you can best represent your client.
And of course, we have 2 lead attorneys on this case from Chicago. They don't practice in front of this judge regularly.
Yeah, that's right. But Arthur Aidala does, and Mr. Weinstein has more resources, more consultants than any defendant I've ever seen in that courthouse. So they're getting advised, and they are getting untold amounts of advice on how to act in front of this judge.
Good insight from the panel here tonight. Weinstein's defense team has raised 3 unsuccessful complaints about a juror who is said to have written an online review of a book about a sexual predator. The review, dated in the middle of the trial, describes in the juror's alleged words the repulsiveness of her predator and her entrapment in the relationship. The her referred to here as a character in the novel named Vanessa. The review also complains, I did not find Vanessa's complete lack of interaction with anyone else is believable. Back during jury selection, the same complaints or similar complaints were raised by the defense that this same juror is also writing a book described as a coming-of-age novel where 3 young women struggle to gain independence after sexual relationships with older, powerful men. Attorney Paul Daraneshian is a criminal defense attorney who practices in Albany, New York. He's handled high-profile cases and appeals in New York. Paul, good to see you here tonight. The case law tells me that the New York Court of Appeals has flipped convictions in the past because of biased jurors remaining on panels. So knowing what we know here about this juror, is this the best issue the defense has to flip any possible conviction that we know of thus far?
Striking issues, however, is the admission of multiple other witnesses of uncharged conduct.
And Paul, I'm not sure if
it was a very impressive decision.
the connection might be cutting in and out, Paul. I think we're going to have to leave you for now. Maybe we'll be able to get you back for some more commentary on this a little bit later on. Let's move on now. A former campaign advisor to President Donald Trump has been sentenced to 40 months in prison. A jury found Roger Stone guilty of 7 counts. They included making false statements, lying to Congress, witness tampering, and obstructing an official proceeding. The charges came from the probe by Robert Mueller into Russian interference with the 2016 election. Prosecutors originally sought a 9-year sentence. Stone will serve a little more than 3 years behind bars. And still ahead tonight, a 40-year-old cold case where a defendant attempts to refute DNA evidence, which the state says links him to a murder. And a jury is split on the appropriate punishment for a career criminal now convicted of murder. We're back right after this. And now to a cold case murder we are following in Iowa, where a conviction hangs almost entirely on old DNA. Prosecutors in Cedar Rapids say Jerry Burns killed then 18-year-old Michelle Martinko back in 1979 when Burns was 25. The 40-year-old case languished until DNA tests were invented and public genealogy databases became weapons for law enforcement. A defense DNA expert disputes the state's theory that the killer cut himself while committing the crime, thus depositing blood on the victim's gear shift and dress.
But the amount of original DNA that was in that cutting is not consistent with what you'd normally get from blood, unless you're talking about an incredibly small fraction of a drop of blood. And there's no trail anywhere else. As you mentioned, a purse, the seats, other areas in the car, or perhaps a trail of blood drops leading away from the car. I saw nothing in the description of the crime scene that supported that there would be a perpetrator cut and spreading little bits of blood in various places.
Was there any attempt to identify any other male profile in the car, the dress, any place in the crime scene?
Yeah, there's other garments. Nobody went back and examined those garments. Once a male profile was found, there was additional examination of what was on the gear shift, the area of the dress F5, and there was typing done on known males to try and identify whether or not those happened to be the known male who was on those areas. But there was no additional searching through other garments or other items collected from the car to see if there was another male.
The defense suggested Jerry Burns frequented the mall where the victim was killed, and therefore his DNA could have ended up at the crime scene through transfer. The state did not buy this.
Bear with me here. If you're wearing a glove and you cut yourself on the inside of the glove, from the outside, just barely get a cut in there, but you cut yourself. I mean, doesn't it make sense that a lot of the blood would pool inside of the glove or instead of being dripped out?
I think that's very intuitive. I would expect that as well.
Evidence of his profile from scrapings on a gear shift selector. You're aware of that, right?
Yeah, I don't think I'd characterize it as his profile. I'd say that it's a profile that is similarities to what was found on the dress.
Fair enough.
It's a partial profile. It was very weak, but what was there was consistent with Mr. You couldn't exclude him, and I agree with that.
Back when Burns was interviewed by police, he was very curious about composite sketches a DNA lab produced to show what the perpetrator may have looked like. Here's what he said when he was approached by police before he was arrested.
Those are the only pictures you had? Those three?
Yeah.
Oh.
So they make one picture. The I'll show it to you again here. So what they do is they take your bad guy's DNA, and then they make this young picture. So this is the bad guy at 25, or it's kind of an estimation. Yeah.
Interesting.
No, I didn't know you in 1979. How old were you? You can do the math real quick.
26.
So you know.
No. 27, 26, somewhere.
You'd know better than we would if you looked like that in 79.
Well, I don't think I ever looked like that. I was a good-looking guy if I did.
Right, right. Well, you probably were.
Let's head now to the conclusion of an Ohio trial where a career criminal was convicted of rape and murder. Anthony Pardon's jury had to determine a punishment for his murder of Rachel Anderson on her 24th birthday. The state presented DNA, phone records, and video of Pardon's acquaintances using Anderson's debit card. The defendant spoke to the jury about his life in and out of prison and about doing time at Ohio's Lucasville prison during a 1993 riot where one officer and 9 inmates were killed in an 11-day standoff.
I learned how to be everything I am in Lucasville. People talked about knives and shanks. In Lucasville, you was gonna get a shank or you was gonna get shanked. That's how it was, ladies and gentlemen. I make no apologies for it. I had to adapt to where I was. Again, wasn't no little boys there. You was a grown man, a grown man. Them screams, them people walking by, them 3 shouts, them people in the sickle doing what they was doing to me. Did anybody care? No. No. Pull your pants up, man. Get on back out there, man. Do what you got to do. You ain't going to no infirmary. So when you hear these stories about Shanks and Anthony Parton's conduct, Anthony Parton adapted to where he was. He was in the jungle. That was the jungle. So I adapted.
The state said having a rough time in prison is no excuse for murder.
This is not somebody that followed all the rules and did the best that he could in prison to get out at 5 years. He did all of his time because he was awful in prison. He continued to exhibit the violent behavior that he had exhibited since he was a teenager and that he exhibited the second he got out of Georgia prison and came here and committed these offenses. At some point, that is not our fault, as he suggested. That is not your fault. That is not my fault. That is not the system's fault. That is his fault. And again, I'm not suggesting that you shouldn't consider the information you heard. But what I'm suggesting to you is to not lose sight of what you heard that were those aggravating circumstances. Again, not 1, not 2, but 5. And it is our position that those 5 aggravating circumstances outweigh those mitigating factors beyond a reasonable doubt. And the only appropriate sentence here is death.
Parton's defense said mitigating factors outweighed the state's 5 aggravating circumstances, including the defendant's sister describing a broken childhood.
Physical abuse. She told you that there was emotional abuse. She said they had no guidance. She said that they moved around a lot. She said that there was no love. She didn't feel any love. She said that there was no school involvement. She said something that kind of pierced my soul when she said, and she's talking about her mother. She said, my mother ruined the lives of everybody she's been involved with. Do you think 5-year-old Anthony, brutally beaten to where bruises are on his body, probably doesn't even know why he's being beaten? You don't think that carries into his adulthood? You don't think that has 0 weight? You don't think that affects choices that he makes? And let's be clear, ladies and gentlemen, we're not talking about excuses. We're talking about what went into making this man who he is. We're talking about what affects his choices.
After about 3.5 hours of deliberations, the jury came back without a unanimous decision.
We, the jury, being deadlocked and unable to agree on whether the aggravating circumstances outweigh the mitigating factors beyond a reasonable doubt, hereby unanimously return the following life sentence, life imprisonment without parole, and what appear to be 12 signatures.
Anthony Parton will be formally sentenced on March 16th. Let's head to our panel one final time tonight. Dina Dahl, this now turns into that automatic life sentence because the jury was hung. What did you think, though, of the defense phrase that we're not offering excuses, we're offering reasons to explain the defendant's conduct? Was that a good argument in your mind?
It seems like it was a successful argument, but I think that maybe the reason why he got life in prison instead of the death penalty was more a reflection of our time. We've seen so much about wrongful convictions of people on death row. Because the reason why he was in prison so much was because he had committed really atrocious crimes. This one in particular was so vicious. The fact they didn't give death penalty, I think, says more about where we are than him in particular.
I mean, this individual's crimes have been increasing in violence as he has gotten older, not decreasing. And a lot of times juries are very harsh with that, though, Dina.
Well, right, which is why I think it almost didn't make sense that they didn't give him the death penalty. penalty. I mean, this was one of the most difficult ones for me to watch. We see a lot of crimes here, but he tortured this woman and killed her in a really vicious way. And the fact that he didn't get the death penalty, my only explanation is because maybe as a society, we've seen too many movies and documentaries about how juries get it wrong sometimes, and they didn't want to be a jury that got it wrong.
Well, maybe, but the evidence was pretty strong in this case, I think. And of course, we've got the haunting image of the cords used to bind the victim and everything shown to the jury. Adam Conta, 3.5 hours is a short deliberation, but there's no dynamite charge in Ohio to try to get the jury to come back with any kind of consensus. So if the jury comes back hung in Ohio, that's it, game over.
Yeah, I think the time that the jury deliberated goes more to the possibility that there were just people on that jury who are just morally opposed to the death penalty. I don't think anybody had any illusions that it might not have been him or that this is going to be overturned at a later time. And as Dina mentioned, this is just one of the most heinous crimes from a truly heinous individual. If you're going to give death to someone, this would be that person. So I think that there were just some people on there who are just morally opposed to the death penalty.
Maybe it was moral opposition. Brian Buckmeyer, from a social justice standpoint, however, it may just be that a few people, or maybe even just one person on that jury, heard about this individual's upbringing and started asking the questions I asked yesterday. Is it the individual who chooses his fate, or does the community play a lot into that?
Yeah, I think there is an aspect of that. I would echo what Adam said earlier, that these crimes, and the ones he committed earlier on, predate his incarceration. So that might be a red herring, but I definitely want to separate that most of our clients that I represent and this one individual, that incarceration does have the ability to exacerbate certain issues like mental health or substance abuse, and that can cause a problem here. I don't think that is as much of the story here with this defendant. So I think that the social justice aspect might not apply to him, but I do think it applies to a lion's share of people incarcerated today.
Exactly. Is prison for incarceration, separation, punishment, rehabilitation?
Yeah, it's supposed to be for a bit rehabilitation, but unfortunately I'm a little too jaded for that, and I've seen too much of the criminal justice system to know that it's not. It's for punishment, and it should not be.
Brian Buckmeyer's opinions tonight, along with Adam Conta and Dina Dahl. Appreciate the insight, as always, here on The Debrief. We are out of time. We're going to be back watching the Harvey Weinstein case tomorrow in Lower Manhattan, and also the Jerry Burns prosecution in Iowa. We'll see you tomorrow on Friday.